Okay, thank you. Good afternoon, ladies and gentlemen. Welcome to our weekly podcast. This is Dr. Olu Asekun. Please invite your friends, colleagues, family members, and join us. As usual, today we will start with updates and then go into questions and answers. I'll be spending exactly 1 hour today because I have to go to court after. Okay, there are only a few updates that we want to talk about today. The first one being that the EOIR, that is Executive Office of Immigration Review, they announced the appointment of 6 new immigration judges and 27 temporary judges. Please bear with me today. I'm just recovering. I don't even know what I had. Is it flu or what is it? I really don't know. But I have to be in court virtually every day, so it's been really, really stressful. But we have to keep going. Okay, so they announced the appointment of 6 new immigration judges and 27 temporary judges. You recall that sometimes ago they decided to bring some military guys to come and act as temporary immigration judges. So I believe those are the 27 temporary immigration judges. To this side? Okay, is it okay now? Okay. Also, the EOIR, when we say EOIR, that is the Executive Office of Immigration Review, and that is the body that regulates immigration law, immigration court. So anyone who is in removal proceedings in court, they are under the EOIR. Even if you file an appeal to the Board of Immigration Appeal, they are still part of the EOIR. So whenever I'm mentioning EOIR, I'm talking about Immigration Court and the Board of Immigration Appeal. Now, the EOIR announced a new appellate procedure. The new appellate procedure will be effective on March 9. I believe today is 11. Yes. Today is February 11. Yeah, the new procedure will be effective March 9. That's probably less than a month from now. However, I am hoping that maybe American Immigration Lawyers Association should go to court to challenge them with this new procedure, because this new procedure is going to cause a lot of harm to people. It's going to lead to a lot of injustice. Currently, if an immigration judge deny a case, a respondent has a right of appeal, and they can file an appeal within 30 days of the decision. However, under the new rule that is going to be effective from March 9, 2026, respondent will no longer have 30 days to file an appeal. That 30 days will be reduced to 10 days under the new procedure.
No.
Yeah.
That's nothing.
It will be reduced to 10 days.
And the fee is so much right now.
Yes, so they won't even give the respondent the opportunity to raise money. So that's not even it. You just listen. That's not even it. In addition, under the new rule, the BIA will determine cases on discretionary basis. Under the new rule, cases will be decided by the BIA on discretionary basis. So what does that mean? That means that the BIA can summarily dismiss a case without providing a reason for doing so, without even providing explanation. They can just write one sentence: this appeal is dismissed. No reason whatsoever. Honestly, I am really fed up with this administration when it comes to the way they are handling immigration laws. This is really frustrating. I just can't understand why they are doing this. There is a reason why courts are set up, and there is a reason why everybody have what is called due process right. And it's a constitutional right in the United States. And that right is not limited to American citizens. Anyone who is subject to the jurisdiction of any court in the United States has the opportunity to go through due process. But this current administration, they are eroding the due process completely. They are eliminating it. In fact, indirectly, they are telling those of us who are practicing immigration law to go and pack up. How do you continue to represent client in this scenario? Why will the appellate court deny a case and not tell us why they are denying it? Why would they not write a decision? Why would they make an appeal subject to the discretion of the BIA? Appeal should be as of right, not a discretionary matter. But under the new rule that is going to be effective on March 9, this is what is going to be happening. A respondent will only have 10 days to file an appeal, and then the appeal can be dismissed by the BIA with or without any reason. They don't even have to give any reason. It is now going to be a discretionary issue for the BIA. This is pathetic. Another update that I want to talk about: if you are currently in removal proceedings, I'm going to advise you to continue to check the EOIR case portal regularly. And when I say regularly, almost every day or every other day. Why is that important? Currently, the EOIR, they are advancing cases that have previously been scheduled for 2027. They are bringing them back. Cases that have been scheduled for later in the year, they are bringing them forward. So right now, they are giving about a week notice to respondent to appear in court. This is ridiculous. Honestly, if I tell you that I understand this administration, the way they are handling things, and I'm really surprised and disappointed that the Congress is not doing anything. The courts are not doing anything. Everybody is just leaving this administration as if this is something that all of them agreed to do. This is like a conspiracy. The very essence of the American system, the rule of law, this administration is tampering with it. Tampering with the rule of law. Those of us who migrated to this country, the rule of law is the main attraction. Believing that you don't need to know anybody. You don't need to have special relationship. Just follow the law and everybody, the same law will be applicable to everybody. But this administration is changing all that. How can an appeal be subject to the discretion of a BIA judge. So the BIA judges can choose to dismiss an appeal without telling anyone. So it may be that they don't even like the lawyer. It may be that they just look at the case and they feel that, oh, this is probably one of those countries. I mean, come on. In the same United States. On one hand, I'm happy that I'm very, very close to retirement. On the other hand, I am pained that the fundamentals of this country is being eroded slowly and steadily, and the Congress is not doing anything about it. I hope it will not be too late. I hope the damage will be reversible.
So does that means that even previously filed appeals can be dismissed? Or is that any appeal filed after that date? Did they say?
Well, they just announced that the new rule will be effective on March 9. So we don't know whether they are going to apply it retroactively or if it's going to be going forward. They didn't say that. Until they start implementing it, that is when we will know how that will be implemented. Now, because of our time, I'm just going to talk briefly about H1B before we proceed to questions. As I stated before, because this is the season of H1B, we are going to be getting updates regularly, and we'll be bringing them to you as they are released. So right now, USCIS, they already announced a new selection process. As I mentioned a couple of weeks ago, the selection will no longer be by ballot. It will be what is called weighted selection process. So now they have explained it further, what they mean by weighted selection and how it's going to work. So according to USCIS, there are 4 wage levels. When anybody is employed in this country, the entry level, maybe for fresh college graduates, entry level, that is referred to as level 1. Level 2 maybe somebody with a master's degree, or maybe where an employer requires some experience. And then we have wage level 3 and wage level 4. However, according to USCIS, for the purpose of the H1B, they are going to be relying on the salary. They are going to be relying on the salary to determine the wage level. In fact, in their explanation, they gave some examples, which I'm going to explain now. Using myself as an example, as a lawyer, considering that I'm a lawyer of several decades of experience, over 30 years experience, I believe that I will fall into level 4 wage level if I'm to apply for employment now. However, what immigration is saying is that it is the offered salary that they will be using to determine the wage level. So, if I apply for a job and the employer offered me $145,000 per year, that will be considered level 1 according to the explanation that they gave. Now, let me explain it differently so that it's clearer. I'm not sure my explanation, the way I was going to explain it, will be clear. Okay, I'm going to give these wage levels. Level 1, 135,000. Level 2, 161,000. Level 3, 187,000. And level 4, 213,000. These are just examples. I'm using the exact figure that they used to explain it to us. Now, if an employer hired me and offered me 213,000 salary per year, under the new weighted selection process, it means that I will be eligible to be considered under wage level 4. Now, what does that do? That means that I will have 4 chances at H1B. I will have the opportunity to be considered 4 times. They will consider me under wage level 1. They will consider me under wage level 2. They will consider me under wage level 3. And they will consider me under wage level 4. So I will have the opportunity to be considered 4 times if I'm offered that wage level 4 salary. Now, on the other hand, if I'm offered 135,000, which is wage level 1, for the purpose of the H1B, I can only be considered 1 time. If I'm offered 161,000, wage level 2, it means that for the purpose of this H1B, I will be selected twice. I will have 2 shots at being selected. If I'm offered 187,000 using these examples that I provided, that comes under wage level 3. It means I will be considered 3 times. So, let's say an engineer, where the prevailing wage for an engineer entry level is $50,000 per year. An engineer with an experience, maybe with 1 year or 2 years experience, prevailing wage level is $70,000 per year. Let's say an engineer with 5 years experience, the wage level is $90,000 per year. Let's say an engineer with 10 years experience with wage level 120,000. Now, using those examples, it means that the engineer who is offered 50,000 will only have 1 shot at H1B for this selection process. The one who is offered 70,000 will be considered twice. The one who is offered 90,000 will be considered 3 times. And the one who is offered 120,000 will be considered 4 times. That is the way USCIS want to conduct the selection for H1B this year, instead of random selection, which was lottery before. So now, what they are trying to do is they are trying to encourage employers to offer higher salary to whoever they are going to employ in order to enable them stand a chance of being selected. So that is the main information about the way that this H1B for this year. So anyone who is selected under level 1 wage, they will have 1 lottery entry. Level 2, we have 2 lottery entries. And level 3, we have 3 lottery entries. And level 4, we have 4 lottery entries. So as we said before, the H1B registration period will open on, I believe, March 4. They will open on March 4 and run through March 19, 2026. Well, because of our time, we have to stop here now and go into questions, because if I continue, we may not have time for questions. It's already 12:20. So let's go into questions, please. H1B is an ongoing thing, so as they will be, I believe they will continue to release more information about it, and as they continue to release it, we will continue to put them out there. But at least that is the most important thing to note relating to this year's selection process. It will no longer be lottery selection. It's not going to be random selection as it was before, previously. So that is the most important thing. So any employer who is interested in hiring anyone on H1B, they need to start preparing, because registration will open on March 4, and will close on March 19. Okay. Good afternoon. First question. Good afternoon, sir. Thank you for all you do, sir. Thank you. You're welcome. My EB2 NIW priority date is October 10, 2024. USCIS have not sent me any decision till now. My date is currently, but no approval. What can I do? Well, if your date is current, okay, yeah, you submitted it to the Texas Service Center. Okay, yeah, if your date is current, you can go ahead and submit I-485, which is the application for permanent resident, if your date is current. However, I'm going to advise you, whatever you are doing right now to keep yourself in status, do not stop it. Continue doing it just in case they don't approve it, so that you don't fall out of status. But for as long as the visa is current, you can submit I-485. So you fill from I-485, attach, you do medical examination, attach your birth certificate, your copy of the visa to show your legal entry, and copy of your I-94, and 2 passport photographs. Of course, you include the receipt notice of the I-140 to show that you have a pending immigrant visa. So you can go ahead and submit the application for adjustment. And if you are married, your wife too can submit application for adjustment, and in fact can use that opportunity to apply for employment authorization by submitting Form I-765 along with it. Next question. Good day, sir. Good day, sir. God bless you for the good work. Amen. My questions are as follows. 1. A recent ruling on the EB1A Kazarian two-step analysis suggests that applicant denied under this framework may have ground to sue USCIS. My EB1A petition was denied last June, even though 3 criteria were approved. Do I have any chance of suing USCIS based on this ruling? Thank you. It is very, very important to understand the idea of suing USCIS. It is not as straightforward as you want it to look. The procedure, if your EB1A is denied, you can actually file an appeal to the AAO, Administrative Appeal Office, because by law, before you can approach the court, you have to exhaust administrative process. So there are administrative procedures. USCIS is an administrative agency. So if they deny the I-140, you can file an appeal to the Administrative Appeal Office, AAO, in Washington, D.C. Now, if the AAO denied it, yes, that is when you can now approach the court. That's when you can file a lawsuit in court. But until you have exhausted the administrative appeal, you cannot go to court. If you go to court, the Office of the Attorney General, who will be defending USCIS, they will file a motion that the case should be dismissed because you fail to exhaust administrative process. So before you can file a lawsuit, you need to file an appeal with the AAO first. So that is the procedure before you can go to court. But after that, if they still deny it and you believe that they are wrong, yes, you can go to court and challenge it. However, I can tell you that you are going to face one obstacle. The obstacle is that I-140, either EB1, EB2, EB3, EB4, or even EB5, it has some levels of discretion. Now, if you meet the requirement and USCIS decided to deny it in exercise of discretion, that may be challenged for as long as you know that you have positive equities. But where you have negative and positive equities, the discretion lies heavily on USCIS, and most of the time, courts are very reluctant to challenge USCIS in the way they exercise their discretion. Let me give you an example. Maybe USCIS believe that somebody is not desirable as a legal permanent resident. Well, they may have reasons which they may not want to share with you. But of course, if you go to court, even if they are not going to share with you, they will be obligated to provide it under seal to the judge, so that the judge can see their reason why they are denying it in the exercise of discretion. But of course, if you don't have criminal record, if you are not associated in any way with terrorism, you have not violated any laws in the United States, sometimes you can successfully challenge them, because where their decision is considered capricious, then the court will intervene and reverse it. It is very rare, but it does happen. I've gotten a federal court before intervene and rule that both USCIS and the Administrative Appeal Office, they were wrong in the exercise of their discretion. But I think I've only done that once. So it's something that is very, very rare, but it is possible. Next question, please. Okay. Okay. USCIS issued me a notice of intent to deny before denying my case, but the denial notice exactly repeated the NID word for word and did not address or reference my NID response. Considering this, please move it forward. Along with the Kazarian issue, do you think I have a viable case? Well, like I said, you need to first file an appeal with the AAO, and you need to do it within 30 days. I don't know how soon they deny this case, but you need to file your appeal within 30 days with the Administrative Appeal Office in Washington, D.C. That is the first step before you can go to federal court. Next question, please. Good morning to you and your team, sir. Good morning, thank you. Please, I want to ask that, is it advisable to appear for an asylum schedule for March with my family? Asking because of the situation of immigration now. Okay, please move it on. I asked, did EB2 NIW, and I've not gotten any reply from that till now. I meant interview for the asylum with my family. Oh yes, you should apply for you should appear at the interview. Interview does not mean that you'll be arrested. No, you can actually appear. There is no reason. The only time you should be concerned is if you have criminal record. If you have criminal record, yes, you should be concerned. But If you don't have criminal record, especially if you enter the United States legally, there is no cause for alarm. You can appear at the interview. They will conduct the interview, worst case scenario. Most of the time, in fact, not even worst case scenario, most of the time, they don't issue interview decision the same day. So you appear for interview, they tell you to come back, usually within 15 days for their decision. But I believe that with the current pause on asylum cases, it is unlikely that they will even issue their decision within 15 days, except if they lift the pause before the 15-day period. But you can go ahead and appear for the interview. There is no cause for alarm for as long as you don't have any criminal record. And of course, if you also want to withdraw your asylum based on your EB2 NIW, but you have to be sure that your NIW will be approved before you do that, because if you do that and then the NIW is denied, you will be placed in removal proceedings and you may not have any relief. So just appear for the interview, present your case, and then you go. For now, they cannot take any decision until the travel ban is lifted, until the pause is lifted. Next question. Good day, sir. God bless you and your team. Amen. Is it okay if I spend 4 months in Nigeria and a month in Canada? Will this affect my citizenship? I'm a 10-year green card holder, family green card, not through marriage. Thanks, sir. Well, I cannot say it will not affect it or it will affect it. The issue is not the 4 months, but the issue is eligibility for citizenship. One of the major eligibility for citizenship is that you must meet physical presence requirement. If you have previously met physical presence requirement and then you go and come back, it will not affect your citizenship since you did not spend up to 180 days outside. But if you spend 180 days outside, any number of days, weeks, months, or years that you have accrued towards your citizenship will be erased. And then when you come back, you have to start all over again, depending on your category. Based on the information you provide, I'm suspecting that your category is 5 years. You have to be 5 years. You have to have green card for 5 years before you can be eligible for citizenship. So far, I don't know how many years or months you have spent here after you got your green card. But no matter the number of years, months, and weeks you may have spent, for as long as you do not stay 180 days outside, you will be okay. But if you spend 180 days outside, whenever you come back, you have to start that 5 year all over again. So, to answer your question, your 4 months in Nigeria and 1 month in Canada will not erase any time you have spent. But if you spend 180 days, when you come back, it's going to erase it. Next question, please. Can an F2 visa holder in the US who got admission apply for adjustment of status, or must she travel back to her home country for a visa interview? If you are an F2 visa holder and you are maintaining legal status, yes, you can apply for adjustment of status. There is no law against it. It is only if you are out of status and you are no longer eligible for adjustment of status, that is when you need to go back to your home country to apply for a visa. But if you are maintaining legal status and you are eligible for adjustment of status, you can apply while you are in the US. You don't need to go out. But if you are already out of status, that is when you may need to go out. Next question. Hello, doctor. Thanks for all you do, sir. Sir, is it true that there is a policy released that stated all immigrants must declare any bank account, pension, portfolio, or investment they have in their home with their tax return in the US Failure to do that will amount to tax fraud. Well, this is not a new policy. This is not a new policy. It has always been the policy of the United States that anyone who is a legal permanent resident or who is a citizen of the United States, they are supposed to declare their income worldwide income. So that has always been the policy. It's not something new. However, I don't think, I've never seen anyone who was actually maybe who was what does IRS normally do? Audited. Yeah, I've never seen anyone who was audited for not declaring their income all over the world. It has always been the policy, and I can tell you, whenever I file my own personal tax return, I always see the question, do you have a foreign bank account? And I always answer yes, because I do have an account in my original home country. So I always answer yes, and that's nothing more than that. I believe there is a threshold of how much you are supposed to make outside before it becomes taxable here in the United States. But to mention whether you have a foreign account, that is not something new. It has always been part of because that is something that I've been doing for decades. It's not something new at all. It has always been the policy. Next question. Is F2 affected by the visa restriction in Nigeria, or they can still proceed with visa interviews? Yes and no. Yes, because they can proceed with the interview, but no, because even after the interview, the embassy will just tell you that they are not able to take any decision right now, that you should be watching the news. If anything changes, you should contact them. They will give you a white slip. We have clients who attended interview after the travel ban. Are they still are the embassies still conducting interview? Yes, they are still conducting interview. In fact, I know someone who attended the interview yesterday at the U.S. Embassy in Lagos, Nigeria. Yes, they are still conducting interview. But are they issuing visa? No. They will just give you a white slip and tell you to be watching the news. If anything changes, you should come back, or they will contact you. But they are conducting visas. They are conducting visa interviews, but they are not issuing visas, immigrant visas. Next question. God bless you and your team, Doctor. Thanks for all you do. Amen. Thank you. Next one. Sir, please, must a parent file for a minor child under family-based petition before the age 18 or 21? Well, the cutoff age is 21 if you want to petition for your child. The cutoff age is 21. After the child turns 21, the child will now be considered an adult. So if you are going to petition for your child and you want the child to be considered an immediate family, you have to file the petition before the child turns 21. Once the child turns 21, the child is now considered an adult and is considered an extended family member. However, the 18-year thing is relevant for the purpose of citizenship. The difference between a U.S. citizen petitioning for somebody before 21 and somebody before 18 is that if you are a U.S. citizen, if the green card is approved while your child is under 18, that child will not get green card. The child will get automatic citizenship. They will not issue a green card. They will issue citizenship right away. But if the child is 18 but under 21, they will issue green card. That is the difference. But the cutoff age is 21. But if you file before they turn 18, and the green card is approved, instead of getting green card, they will get citizenship directly. That is the difference between age 18 and age 21. Next question, please. I'm in Nigeria. My daughter is in Dallas, Texas. I have my 5-year visa to expire 2028. I visited once. I'm planning to visit again. Hope there be any problem. She's still expecting a 10-year stay. Is it a continuation? Also, will I be able to land in Dallas airport? Oh yes. Oh yes. If you have your valid visa and your visa has not been revoked, yes, you can come to the US without any problem. You can fly through any airport. I know people who continue to use their visa. I have a friend who visited from Nigeria. He has his 5-year visa and it's still valid. I know a lot of people who go in and out of the country without any problem. The only time you have to use the designated airport is if you are subject to the visa bond. If you are just applying for visa and the embassy inform you that you have to pay a visa bond, then that one you can only come into the US through any of the designated airport. But if you already have your visa, you can go through any airport that you want. There is no problem at all. Good day, Dr. Asekun. God bless you and your team for squeezing your time, not minding your tight schedule to give us updates and answer our questions concerning the immigrations. Thank you. Thank you. You're welcome. Yeah.
Let me see. I think she sent this question.
Okay. My priority date is 2018. I have been denied of my I-485 many times, and I found out that the mistake they pointed out is mainly from my lawyer. Please, I need your advice. Okay. Any details I get, I do not have enough time to search for another lawyer. Due number of days they wanted me to file I-290B. Thank you, sir, and God bless you. Well, it depends on the error from the lawyer. I've said it multiple times on this platform that considering my age and my experience, it is not my desire to have anybody's career destroyed. I don't desire any joy in seeing people's life destroyed. So I don't know the level of error committed by this lawyer. However, if you are certain that the mistake is actually from the lawyer, that you can actually refile your case under what is called matter of Lozada. Lozada, matter of Lozada. Now, what does matter of Lozada mean? It means that where your case is messed up by your lawyer, you have to take 3 steps. And if you take those 3 steps, then you can refile your case and immigration will not use that lawyer's error against you. These 3 steps, the first step is that you must file a complaint against that lawyer with the state bar from the state where the lawyer is licensed. You must file a complaint against the lawyer. 2, you must serve a copy of that complaint to the lawyer so that you give the lawyer the opportunity to defend himself or herself. It's not going to be a one-sided story. So you must give the lawyer the opportunity to defend himself or herself. And of course, if the state bar determine that the lawyer actually made a mistake in your case, then you can use that to refile your case. It doesn't matter how long after. I've actually used matter of Lozada to refile a case that has been over the appeal has been due for several years. But again, you have to be sure that the lawyer actually made a mistake. In my career, since I've been in this country, I've had, I think about, is it 2 or 3?
I think it's 2.
Okay. I've had 2 cases. I had 2 cases filed against me, and both of them were frivolous. Why did I say frivolous? The first one, the person filed the complaint alleging that I told him that, look, I'm a Christian and I cannot lie to you, that your case is very weak, that you don't have a strong case. This case is not likely going to be approved. And he filed that complaint that I told him that, and he believed that because of that, I didn't do a good job. That was why his case was denied. Of course, the state bar didn't even ask me what happened. They just dismissed the case. But they notified me that this is what was filed against me, but they just dismissed it. They didn't even ask me for my own version of the story. The second time, a lawyer in California, I believe it was in California.
I remember the state. I remember the case.
Yeah, I think it was in California. A lawyer in California wanted to help somebody, a former client of mine, and they put up a complaint against me. In the complaint, they claimed that the client tried to reach me and they were not able to reach me, that they have changed my number, that the client came to my office, I have moved my office. They made all kinds of serious allegations. But the lawyer sent a copy of the complaint to me. So I responded to the lawyer. And after I responded, I don't think the complaint was ever filed, because I blasted the lawyer that I don't expect somebody who is licensed in the United States to put up this kind of frivolous complaint, because a search of my name on Google will tell you that since I've been practicing, my office number has never changed. My office number has never changed. My office address has only changed one time, and that was because we moved from where I started practice to a permanent office that is our own. That was one time. But this particular complaint was before we even moved. I remember when the complaint was filed, I've been at that same location for 17 years. So I told the lawyer that just go on Google, you will see my address, you will see my name. My address has never changed. My name has never changed. My phone number has never changed. All these lies that you are concocting, that if you submit this, I'm going to go after you as a lawyer. And I don't think that complaint was ever filed, because I never received anything from the state bar. So if you know that the lawyer actually made a mistake, then you can go with matter of Lozada. Next question, please. Doctor, sir, is it a good option for parents to submit another application separately for a child that has just turned 18 years under their pending asylum case in an immigration court? No, it's not necessary. The cutoff age is 21, not 18. So when a child is still 18, they can still be under your own application. They don't need a separate application. Next question. Hello, sir. Are EB4 and R1 the same? How does the EB4 sunset date of January 29 affect my R1 petition? Will the ban on my country impact the petition? Well, R1 is a non-immigrant. EB4 is an immigrant. Both of them are the same, but R1 is a non-immigrant version. EB4 is an immigrant version. And EB4 encompasses other things other than religious workers. R1 is purely religious workers, but EB4, under EB4, you have multiple immigrant visas, but one of them is immigrant religious workers. So they are the same thing, except that R1 is temporary, EB4 is permanent. Now, as to the sunset date, the sunset does not affect ministers. It only affects non-minister positions. It does not affect ministers. So since I don't know whether your case is a ministerial one or non-ministerial one, I'm not in a position to tell you whether it will be impacted or not. But generally, because of the travel ban, if you are from one of the travel ban countries, that may affect the decision on your case. The timeline of taking decision may be impacted. But if you are a minister, the sunset does not affect you. It only affects non-minister positions. Next question.
Part 2 of the same question.
Okay. What is the implication of withdrawing the R1 petition given my legal presence? How will it affect my immigration history? I'm very worried. Well, there is we don't have enough information. So what would lead to withdrawal? Was this application filed before the expiration of your I-94? Were you still in status at the time you file it? Because I really don't know the details. So I'm not in a position to tell you whether to withdraw it or not. But one thing I can tell you is that if you file the R1 application and USCIS issue a receipt notice before the expiration of your I-94, that keeps you in legal status. You do not need to do anything other than to wait for the adjudication. Even if it is later denied, your unlawful presence will be from the denial date. It will not be during the period that your case was pending, if that is your concern. Next question, please. Hi, can someone with approved T visa apply for advanced parole, and will you advise travel with it if they initially EWI? I'm trying to remember. Can someone remind me? I think there was something, there was a policy change regarding T visa and EWI recently. I can't remember. There was a kind of policy change.
It is for an EOIR entry.
Yeah, that's something that I'm trying to remember. Please note this question. I may have to provide an answer later. I don't want to provide an answer that is not accurate. If the person can also send the email address so that I can send a response to the question through email, or if you remind me later. But there is something about T visa recently that I can't remember right now.
Remember you mentioned something about T visa just now.
Yeah, there's something I can't remember, especially with the EWI thing. I think there's something about it recently. I can't. The policy changes have been so much. It's difficult to keep up everything in one's head. But I will check and get back to you. In the meantime, go to the next question while you check for me, please. Hello, sir. Good day. In terms of AOS, adjustment of status, having already filed I-130 and I-130A online, is it a better option to file I-765 and pay the online filing fee rather than wait to file physically with I-485? No, it is not a better option. It is not even possible. I-765 is connected with I-485. So the fact that you have I-130 pending does not give you employment authorization. Employment authorization is associated with I-485. So before you can file employment authorization, you need to file I-485 first. You can either file it first and get a receipt notice and then file I-765, or you can file it concurrently, I-765 together with I-485. But you cannot file I-765 based on I-130. I-130 is just the petition. It does not give you the opportunity of employment authorization. It is I-485, application to register permanent residence or adjust status. That is the one that gives you the opportunity to apply for work authorization. Next question, please. Good day, sir. You are the best. Oh, thank you. I'm currently in immigration court proceedings. I filed for asylum before my I-94 expired, and my priority date is now current under EB2 NIW category. My attorney requested an earlier hearing date, but the court does not have any availability. I would like to understand whether there are any options to expedite my case. Please move on. Or if I should consider filing I-485 directly with USCIS. I'm trying to explore every possible path to move forward with my adjustment of status. I appreciate your guidance you can provide. Well, I'm not sure if the writer of this question is a regular listener on this program. For regular listeners, you will recall that I mentioned a case where somebody with a pending asylum that was filed before the expiration of the I-94, and then the person has an EB2 approved and then apply for adjustment of status. Immigration denied the adjustment of status on the ground that the person is out of status. This is a subject that I've addressed on my podcast several times, and I continue to address it. The position of the law and my position, which I've argued multiple times at immigration court, is that if someone filed an asylum before the expiration of the I-94 and that asylum is still pending, and then the person have an approved immigrant visa, the person is legally eligible to apply for adjustment of status, because the moment the asylum was filed, that person's status is frozen. Although the person does not have legal status while the application is pending, but the person remains in the United States lawfully based on the pending application. Now, because of that one case that was denied by USCIS, I had the impression that this administration is trying to change their decision, their policy on this matter. So what I've decided to do is to challenge them at the federal court. And that case has been filed at the federal court in immigration. Please, can you give me the case number? If there's a way you can post it. Post the case number. Just the case number. Don't mention name. Just post the case number. Yeah, that's a public record. Yeah, you can show the case number. So the case has been filed. I said it under during this platform that I am going to challenge USCIS because I believe that they are wrong. So I have filed the lawsuit. That case is pending. Whenever you file a lawsuit against an agency of the government or an employee of the government or the federal government itself, that case can only be defended by the United States Attorney General. And the court, the federal court, will give the government 60 days, which is 2 months, to file a response. So consider that is even 60 days from the date of service. As of today, I'm not sure if they have been served, but I doubt it. I don't think they have been served, but the case has been filed. So I promise that I will be updating us as we go. So now, why is that case relevant to this question? It is relevant because if I'm in your shoes, I would rather wait and see the outcome of this case rather than rush the court and then have the case denied. Because if this is actually a policy change by the current administration, there may be likelihood that it may be denied. So if I'm in your shoes, I will wait to see the outcome of this case. But again, if you don't want to wait, you and I, everybody know under this current administration, the court is currently jam-packed. But considering the fact that EOIR is actually moving cases forward, hopefully on their own, they will move your case forward. Hopefully. But other than that, if I'm in your shoes, my first option would be to wait and see the outcome of this case that is similar to mine. It's always better to just use somebody's experience to gain benefit than you being the guinea pig. That is what I will do if I'm in your shoes. But again, it is not certain that this is actually a policy change. It may just be the officer who denied that case that is not familiar with the law. But I wrote a brief in that case where I explained to them, because when they denied it, I filed a motion to reopen, and I submitted and I supported it with a brief where I explained to them that they were wrong, that this case is approvable. But again, they denied the motion to reopen, which was why I went to the federal court. So the case is currently pending. Have you posted the case number?
Yeah, I just did.
Okay. Yeah, so the case is pending. So if you are interested, just follow us. But from time to time, whenever people ask questions about it, we will update you in this on this platform. But the case is currently pending. It is pending at the Federal District Court, Middle District of Florida. I filed the lawsuit and is currently pending.
Additionally, USCIS wouldn't have jurisdiction over the I-45s.
Yes. Still talking about this particular question. If you go back and refile your I-485 with USCIS, they will just administratively close it, and you may not even get your filing fee back because USCIS will not have jurisdiction over someone who is in removal proceedings. So USCIS cannot help you in this case. The only thing I can think of is probably file a motion to terminate proceedings to allow USCIS to adjudicate it, which I doubt any judge will approve under this current administration. But USCIS currently does not have jurisdiction over your case. Next question, please. Good day, sir. I want to appreciate you and your team for the wonderful work you are doing.
No, the one above it.
The one,
Oh, there is one on.
Yeah, one above it.
the one on top.
Oh, okay. Thank you.
You're welcome.
Good afternoon, sir. Will the use of Medicaid by beneficiaries' children affect AOS? Well, were those children U.S. citizens? If they are U.S. citizens, I don't believe it will affect them. But if they are not U.S. citizens, then that may be trouble. Next question. Good day, sir. I want to appreciate you and your team for the wonderful work you are doing. Thank you. Is there any update on the processing of green card and citizenship applications? May God bless you all. Amen. Well, I don't know if this person is referring to the travel ban countries or general, because the truth of the matter is that USCIS is still working. They are still adjudicating cases. They are still processing cases. They are still approving cases. It is only the travel ban countries that are affected. Other than that, everything is still going on normally. They are still processing everything. And even the travel ban does not affect people in removal proceedings, because I continue to get green card for people, even people from travel ban countries. This week alone, I have secured green card for clients who are from Nigeria through the court. I mean, same thing last week. So the courts are not affected. Only USCIS is affected. So the travel ban does not impact court proceedings. So if you are eligible for adjustment of status in court, the travel ban does not affect you. But if you are not from the travel ban countries, everything is still going on normally. Nothing is affected. Next question, please. I'm on EAD. Can I do change of status to EB2? I just finished my master's, been here for 5 years. Well, this is not a complete question. EAD is not a legal status. So we need to know what your legal status is. Are you on OPT? How did you get the EAD? So it is the legal status that determines your ability to apply for adjustment of status, not the EAD. EAD is not a legal status. Somebody may have a valid employment authorization and still be out of status. So EAD is not the issue. Please check the time. Don't let me. God bless you, sir. May you get well. Amen. Thank you. Thank you. Good day, sir. Well done to you and your team. Please, what's the update or position on OPT and VAWA as at now? I had applied for OPT before the pronouncement of my Nigeria as partially banned country. Unfortunately, OPT is also part of it, because F1, I remember the travel ban specifically addressed F1. F1 is part of it. So if you have submitted your OPT application, just wait and hopefully when they review it in 6 months, I mean the 6 months time, I believe that 2 months is already gone now. Yeah, almost 2 months is gone, because this was since December.
January 1st.
Huh?
January 1st is when this one started.
No, the F1 was that January 1st?
Well, they said that like the
I think it was December 26th.
I thought it was for people in the US. It started January 1st and it was 90 days from that.
Okay. Well, even if it is January 1st, I mean, this is the 2nd month. So hopefully we will see. Well, for those that had a temporary pause, those ones are 90 days. They give USCIS 90 days to review it. Yes. But for those who are general pause based on the travel ban, those ones are 180 days to review it.
Yeah, you're right.
Yeah, they review it after 180 days. So next question. Good morning, sir. Thank you for all you do. I wanted to ask if my 2-year green card physical card is lost and I have the 48-month extension letter. What can I do to travel out of the US? Unfortunately, you cannot use the extension letter if you lost the physical card, because the combination of physical card and the extension letter is what will enable you to come back in. So if you have lost the physical card, the only thing you can do is to schedule an InfoPass appointment and go and get your passport stamped. If your passport is stamped as a permanent resident, then you can use that to travel. But the extension letter itself is not enough for this purpose. Otherwise, you will not be allowed to come back in. So it is the combination of the extension letter and the physical card that you need. Okay, second question. Please check the time. Don't let me
Answer
exceed.
2 more questions, and then we'll do the
And then
thing.
you can start announcing people that.
Yeah, they can
we're gonna
start.
do the giveaway.
Okay.
But no, not right now.
Okay.
Okay. Second question. Can someone still attend US B1, B2 appointment in Nigeria with the ban in place? Oh yes. You can attend it. You know that the ban has some exceptions. If, for example, you are an athlete, you may be exempted. And secondly, they can still exempt you and ask you to pay a bond. Yeah, go ahead and attend it. I mean, the only thing is either they give you or they don't give you. They can't detain you. So why not? Go ahead and attend it. So next question. Good day, sir. May God bless you and your team in Jesus' name. Amen. My under 21 petition for him by his green card holder. Okay. My under 21.
Child?
No, he's talking in third person. He's talking about somebody else. Okay, my under 21 petition for him by his green card holder dad. Case is at NVC stage, but I'm scared. I want to know if we should reschedule. NVC does not conduct interview. What are you going to reschedule?
And then there's a follow-up that says when we finally receive the interview date because of the visa refusal. Thanks.
Oh, we should finally reschedule when we finally receive interview date because of the visa refusal. No, this is an immigrant visa. They cannot deny it without reason. You can still attend your interview. If you attend the interview and everything is okay, the only thing the embassy will do, they will give you a white paper and tell you that they are not able to issue a visa right now, that you should be watching the news. If anything change, you can contact them or they will contact you. But that's not a reason to withdraw your application. It's an immigrant visa. If it is the green card holder dad that filed the petition, yes, you should go for the interview. Worst case scenario, they will delay the issuance of the visa, but it doesn't mean they will deny it. Next one.
This lady is commenting on the new policy
Yeah, the BIA.
about the BIA thing.
Oh, okay.
Yeah.
Yeah, the Lord is your strength. Thank you. Amen. I'm on F1 visa. I have my fiancée, whom I have been dating for 1 year, and we are preparing for marriage. She got admission in Caribbean and will leave in January. We have passed January already. Do you think we can do online marriage? No, not for immigration purpose. Immigration will not accept online marriage. Okay, is that a continuation? Okay. Can we still get married while she is in Caribbean and still file for me while she's in there? This has been a frustrating for us. Can she file for me while not being present in the US? You see, this is not going to be an easy task. However, it depends on your peculiar case. First and foremost, you cannot do online marriage. Secondly, she cannot file for you if she is not in the US. But if you are dating and ready to marry legitimately, if she has holiday, she can come back in, you get married, you submit the petition if you have been living together, because we don't have enough information with this case. You've been dating for 1 year, but have you been living together before now? Have you been commingling your assets before now? If you don't have any of these, yes, you can still get married. You can still continue to communicate. She can continue to come back home. I'm not sure if you have legal status to be able to travel to Caribbean. If yes, you can also go there. I mean, All these will be part of your evidence. Immigration cannot say that somebody should not go to school, but at the same time, they must see evidence of the relationship. To be honest with you, in my own opinion, in a legitimate relationship, you will communicate virtually every day. Even if your spouse is not in the US, you will communicate virtually every single day in any legitimate relationship. In fact, I've represented a client before who was brought into the US by a US citizen on a fiancé visa. When she got to the US, they went to the marriage registry, they got married, and the guy decided he was not interested anymore. Guess what? At the end of the day, I was still able to get green card for this person, relying exclusively on the communication between them when they were dating. Because the truth of the matter is that, if you are dating somebody for real, you can't wake up one day and spend 24 hours and not communicate with that person. So all the communication will show that this is a legitimate relationship. And of course, during holidays, whenever there is an opportunity to come home, she will always come home. And even from Caribbean, you can still commingle assets. You can still use the same joint bank account. There are things you can still do that will establish that this is a legitimate relationship. But is it going to be straightforward? No. This will definitely raise a red flag. Red flag does not mean denial. It means look more closely, investigate further. So they will actually scrutinize it more than the regular filing. But it is still doable, but not by online marriage. Is that the last for today? Okay. I think today is the giveaway, the free consultation. So what should people do now?
So they can start commenting the free consultation.
Okay. For the giveaway today, if you are online, you can start commenting free consultation at this time.
Let them know that one comment is more than enough.
Yes, you don't need to do it multiple times. Just one time is okay, but send in your free consultation comment. And I also know that the requirement is that you must be subscribed to our channel. And secondly, of course, you must be online right now. If you are not online, you won't even know that we are doing this. So if you are listening now, that simply means you are online. So free consultation. So how many minutes do we wait before you?
5 minutes? Okay, 3 minutes.
Okay, so continue sending in free
So
consultation.
121.
Okay, yeah. We will wait the next 3 minutes. Are you coming to take over? Yeah. So I hope to see you again next week. Whoever wins the free consultation, we will see and consult with you.
So I'm going to start putting them as they feed the chat.
Okay, good afternoon, everybody. For those of you who are frequent listeners or watchers to our podcast, then you may recognize me. My name is Kimberly. I'm a paralegal here at the law office of Olu Asekun, and I've even hosted the podcast a couple of times. So Dr. Asekun had to run off. As he mentioned, he has to be in court today. So I'm going to be hosting the giveaway for the free consultation. So what you need to do is go ahead and, as he mentioned, comment free consultation in the live chat, but please only post it one time. If you post it more than once, it's not going to increase your odds. So it's best to just go ahead and post it only one time. and we will go ahead and select one of the people who have commented. As long as they are subscribed to our channel, then they can go ahead and win a free consultation, and we will make sure to fit you in within the next week. So, week and a half?
Yes, around there.
Well,
I
no,
will do our best.
Wednesday. Yeah, Wednesday.
Just to give more.
Okay, yeah. Within the next week and a half. So, go ahead and send in your comments. And once we pick the winner, then we will have you text a picture showing that you are subscribed, and it has to include your handle as well to show that you are the person who won the free consultation. And we will give you that number. Well, while we're waiting, I can go ahead and give you the number now. So the number that you're going to text the picture to for the winner is going to be 817-891-6655. I'll mention it again after we announce the winner. Okay, so right now it's 121, so no more comments. If you comment after this right now, then unfortunately your comment will not be included. So we are going to go ahead and do a random selection. I don't know, for anyone who's watched in the past, we do a little wheel thing that does a random selection of the winner. So Marissa is just assisting me with that right now. So again, we will try and get you squeezed in as soon as we can for your free consultation. So, and again, thank you to everyone who's been, watching and listening over this, past few years that we've been doing this. And, we thank you to all of our subscribers who, come back every week. I know it's important to stay informed during this present time with this current administration, but we thank everybody, all of, our subscribers, everybody who tunes in every week and, does this to stay informed. Because as Dr. Asekun always says, first of all, immigration is not a one cap fits all. I mean, every situation is different. So it's really good to stay informed so that you don't make any small mistakes, because we have seen so many cases be so derailed over such a small mistake that could have been avoided. So that's our main goal, is to ensure that anybody who listens to our podcast does not make those small mistakes that could end up, derailing your entire case or send you on a years-long detour that could be avoided. So again, we thank you so much for tuning in, and also feel free to subscribe or, go ahead and follow our other channels. We're on Instagram, TikTok, X, Facebook, and YouTube. So we frequently announce things like the free consultation giveaways on Instagram and TikTok, and on YouTube and Facebook, on all of them really. So if you are following along on those channels, then you may be able to see that, oh, okay, they're going to be doing the free consultation this week. Or if maybe we're starting the podcast a little bit early because the lawyer is going to be in court, we do announcements like those. So it can help to follow along. And we have posted many shorts in the past. We're going to actually start posting the shorts again. I don't know if anybody knows the Do You Know series that Dr. Asekun does, where he gives out the little bits of immigration information. We're going to start doing more of those soon again too. So it's important to follow us. Okay.
I have all the names.
So Marissa has compiled all of the names for everybody who's entered into the giveaway, and she's going to display it on the screen. Oh, can we take...
What do you want me to do?
No, sorry. I just wanted
Oh,
to...
yes.
Oh, I don't even know if it's going to still be there.
No.
Okay. That's okay.
I should have removed it.
It's okay. It's okay.
Well,
Okay, that's fine.
Focus.
Uh-huh. Other way. There we go.
There you go.
There. Okay, so all the names are in that little wheel, so we're going to go ahead and
Tap and spin.
tap and spin. Ooh, that's a lot of names. That's a lot of colors.
Yep.
Okay.
The winner is...
The winner is there on the screen.
Abu
Abu Dhabi 7329. So congratulations to Abu Dhabi 7329. If you can go ahead and text the number 817-891-6655 showing a screenshot that you are subscribed to our channel, and then additionally a screenshot showing your handle to prove that you are, the person that has won. So congratulations again. So go ahead and send those to us, and we will have our receptionist go ahead and get you scheduled as soon as possible. Hopefully, like I said, within the next week and a half. So congratulations again.
Okay.
So, okay, we hope to see you again next week by God's grace. Go ahead and tune in to our channel live every Wednesday at 12 p.m. Or if it's going to be earlier, we will post the day before to let everybody know. So again, be sure to follow us on all of our social media, and we will see you next week. Stay blessed and stay out of trouble.
Mhm.